will hand over to Günther and leave you to conduct the final round. I'll get a call when we go live.
You're live now, Patricia.
I welcome you all to the final round in the 29th Willem Vis International Commercial Arbitration Moot. The final round is live streamed. I welcome all participants that are here in Vienna and that have come to watch the final in the Hofburg, in the beautiful Hofburg, the Emperor's Palace in Vienna, but also a warm welcome to all of you who are at different places in the world and watch the final, hopefully very comfortably in front of your screen. The results of this session will be announced at the closing ceremony at 3:30 p.m. Vienna time today. The closing ceremony will also be live streamed. In the past 5.5 days, more than 360 teams have pleaded in nearly 800 oral hearings. This is a number that probably no other arbitral institution or hearing center has ever handled within such a short period of time. A huge thanks to the marvelous team of the IDRC who made this smooth operation possible. We have reached now the end of our competition with 2 teams left that have prevailed amongst so many teams that already impressed the arbitration community with their outstanding performance. The level of performance and the quality we saw in this year's Vis Moot is impressive. Let me present to you the final teams in the 29th Vis Moot, which are the University of Hamburg and Sofia University St. Clement Ordiski. The speakers of the Hamburg University team who will represent Claimant in the final are Ms. Lara Schmidt, who will do procedure, and Ms. Eva Gott, who will do merits. Respondent will be represented by Sofia University, and the speakers are Mr. doing the merits and Mr. Ivan Ivanov doing procedure. It's also my pleasure to present to you the arbitrators of the final round. And I will start with the co-arbitrators. Ms. Jan Bao, she's the Vice President of the ICC Court of Arbitration and Chair of the ICC Commission Task Force on ADR and Arbitration, and Vice Chair of the IBA's International Arbitration Committee. From 2010 to 2000, another friend of the Vis Moot is Günther Horvath. He will chair the final panel. He's the president of the Vienna International Arbitral Center. In his previous role as a longtime partner of Freshfields Bruckhaus Deringer, he has led the firm's international arbitration group in Vienna. Günther has acted as counsel and arbitrator in over 150 high-profile disputes under the major rules of arbitration. He works as an independent practitioner in Vienna and holds board seats in leading European industrial companies.
Thank you very much, Patricia, for this kind introduction and your very nice words. Much appreciated. To our global audience, most cordial good morning, good evening, or good afternoon from Vienna. It's a brilliant day here, and we have a brilliant event ahead of us that we are very much looking forward. On behalf of the Arbitral Tribunal, let me therefore welcome you wholeheartedly to the hearing in this arbitration, the case reference AIAC/INT/ADM 1232021 between Claimant, Elka PLC of Mediterrano, and respondent Jaja Biofuel of Equatoriana. As Patricia said, my name is Günther Horvath, and I have the honor to chair this hearing. With me on the panel are my co-arbitrators, Lisa Spagnolo and Can Bao. In accordance with procedural order number 1, we asked the parties to address the following issues in this hearing, and I will come back in a second on the way we suggest to address those issues. A, have the parties validly agreed on the jurisdiction of the arbitral tribunal? I, what is the law governing the arbitration agreement? II, is the CISG applicable to the conclusion of the arbitration agreement in the event it is governed by the law of Mediterranean? B, have the parties concluded a contract in 2020? And C, if a contract was concluded, were claimant's general conditions of sale validly included into the alleged contract? As to the structure of your pleadings, we have the following suggestion, which is maybe not going the usual way, but it's a mixture of the common way and the more innovative one, where we will have a more lively debate on the issues. We would ask...
Arbitration clause was incorporated into that contract.
Okay, okay, excellent. And to have a clear understanding, that would mean that issues B and C will first start with issue B, have the parties concluded a contract in 2020, then the other side will, which is on the merits yourself, you will respond to that, and then we have a rebuttal and surrebuttal of, let's say, a minute each, and then you continue. Claimant on issue C, if a contract was concluded, were claimant general conditions validly included, and you can respond, and then we have rebuttal and surrebuttal.
Concluded no less than 40 contracts previously. Against this backdrop, claimant has 2 submissions. First, in the very last line of this box, it reads, seller's general conditions of sale apply. This was the offer made by claimant on the 9th of April. And this offer was accepted by respondent on the 16th of April through silence in line with a respective business practice. And I would like to make 3 arguments to this point. First, the business practice established between claimant and Southern Commodities also binds respondent. Second, under this business practice, no performance was necessary. The court also ruled that they don't need to be. Under this rationale, the circumstances of each case must be regarded. And the circumstances of this case show that it was reasonable for claimant to expect that this business practice would apply again.
Counsel, can you please?
Go
Sorry.
ahead.
Go ahead. Are the ones that are being proposed, and that would seem to indicate she's not on the same page as the claimant. And this brings me back to the problem. We don't have any indication from Ms. Bapati that there's some sort of agency going on. She's clearly acting for a new entity here, and there's no estoppel or other sensible authority to indicate there's a connection with Southern Commodities. So perhaps you can assuage my fears here.
Yes, so I will first address the first point raised by Madam Arbitrator regarding the lack of a signature. However, this point wasn't accepted by claimant, as claimant in the reply to this email simply stated that they would need a signature for the eventual performance. And when we are looking at this issue, we need to separate 2 spheres. There's the sphere of contract conclusion and the sphere of contract performance. And while there was a signature necessary for the sphere of contract performance, it wasn't yet necessary for the sphere of contract conclusion. And therefore,
can I interrupt you here? Would it make a difference if the employee actually would have moved to a company which is not a subsidiary of the company he had been working before? Would that be making a material difference in that respect? And attached to that, is it relevant that there is a sizable group of employees moving to the other company, like a department, like the purchasing department, or would a single person just moving from one entity to the next one get the new company into a relationship which it probably didn't even know it existed before?
As Madam Arbitrator has also raised 2 points previously in our question, should I address those points first?
Yes.
Before I come to
Yes,
your
combine them, please.
Thank you. So the second point Madam Arbitrator raised was that Ms. Pupati in this email indicated that she was still assuming that the 2010 version of the general conditions would be applicable. However, what Ms. Pupati is referring to here is the arbitration, which Ms. Pupati in this email indicated that she was still assuming that the 2010 version of the general conditions would be applicable. However, what Ms. Pupati is referring to here is the arbitration, which is the dispute resolution mechanism. And in the present case, work closely together and are related to one another, as Southern Commodities now is not in the business of palm oil anymore. So if one would go to Southern Commodities and ask for palm oil, they will refer you straight back to respondent. And the business practice established was that if Ms. Pupati didn't object to the terms within 1 week, she had accepted them. And in the present case, respondent didn't object within 1 week and therefore accepted the contract. And coming to my second submission, that in this contract, claimant's general conditions of sale were included. Now, I've already spoken a little bit on the fact that that's agreeable. Of course, a dispute resolution mechanism is material. This is also stipulated in the CSG in Article 19, Section 3. But this is in regard to a consensus regarding contract conclusion. And what we are looking at is the inclusion of general conditions. And here, the general conditions contain an arbitration clause.
Is not as important as business practice. Is that my understanding as your position?
Of course, the meeting of the minds is important in the present case, but what we have to look at is the point where that meeting of the minds happened. And the meeting of the minds happened after Mr. Chandra had sent the contractual documents and Ms. Pupati stayed silent, indicating to claimant that nothing was wrong with those contractual documents and they were accepted by respondents. So in that case, there was a meeting of the minds.
Coming to closure, or is it already relevant?
Of course, Mr. President, it is relevant. The negotiations are relevant because they can point us to the intent of the parties and they can point us to whether there was an actual meeting of the minds to enter into a contract. And we do acknowledge Ms. Bubati and Mr. Chandra have a long history. Ms. Bubati and Mr. Chandra did meet at the Palm Oil Summit, and already at the Palm Summit, they agreed on the commercial terms of the contract. However, I would like to direct your attention precisely at the discussion that occurred at the Palm Oil Summit on page 10 of the case file. And if you could please be so kind to indicate when you're following me.
Okay, thank you.
Page 12 of the case file, the largest producers of coal worldwide, and also within Southern Commodities, where environmental concerns also played a minor role, unquote. Now, members of the tribunal, of course, what is the significance of this discussion between the parties? The significance is that opposing counsel relied on the case by the Austrian Supreme Court that affirmed that parties can rely on their good faith expectations that previous practices between the parties could be observed. And here is the critical issue between the parties, because already at the Palm Oil Summit, Ms. Bupati, respondent's employee, was explicitly clear that Southern Commodities and respondent are two completely different legal entities driven by different political considerations. And what are the impact of those political considerations? The impact of environmental activists playing a role in decision-making in respondent is the following. Respondent is obviously going to be more careful when entering into transactions for the sale of palm oil. It will obviously need to take more time to consider whether such a risk is justified, considering that environmental activists could attack its business. And if that is not a sufficient distinction between respondent and Southern Commodities to the tribunal, I would like to point your attention to another fact.
In those documents, and then you guys that seem to be what would be obvious to a reasonable person looking at this situation on an objective level, that there is an existing contract between them. I mean, who opens a letter of credit unless there's an existing contract?
Madam Arbitrator, in order to address your question, I would like to ask the tribunal to please follow me on page 30 of the case file. And page 30 of the case file will exhibit the email sent by respondents' employee, Ms. Fauconnier, when Ms. Fauconnier inquired about the list of acceptable banks, as Madam Arbitrator has asked. And if the tribunal is with me, in the 4th paragraph of that email, this is, and if I cannot be of any further assistance to this tribunal, I would like to thank you for the attention and conclude my pleading.
I would have a very simple question at the end, if I may. Are you saying that or maybe you're saying that had Claimant a duty to provide Ms. Bubati with a copy of the general terms?
Mr. President, Claimant is not obliged to provide us with a copy. Rather, there are other options to make respondent reasonably aware of the contents of the standard terms. For instance, as affirmed in CSG Advisory Council Opinion number 13, it could be because respondent has prior knowledge of the contents of the standard terms that their incorporation could be possible. However, such prior knowledge does not exist because Ms. Bubati cannot reference see the standard terms for future reference, and because obviously she forgot about the entirety of their content, and therefore they were not made reasonably available to her.
But that gets us back to the previous question. I mean, is it who has the actual knowledge, who has the past experience? I mean, it's the employee. I mean, the company itself has no memory, so to say. So it has the memory through its employees. Isn't that exactly the case here? She knew exactly what's going on for a number of years, 40 contracts we have heard.
Mr. President, it cannot be expected that Ms. Bubati, when occupying her position in Southern Commodities, was trading only with Claimant and thus was familiar and knew by heart Claimant's general conditions and its general terms. It is only reasonable that after she transfers companies, the general terms are made available to her again, and not merely because she transferred companies, but also because those general terms underwent 2 changes, and thus she must have been made aware of those changes in the context of the entirety of the general terms.
Okay, thank you. Do my colleagues have an additional question? Thank you. Okay, fine. Then we had agreed before that there is a chance of a rebuttal. Councillor, would you please go ahead? Thank you.
Opposing counsel relied in her submission largely on the fact that Ms. Bubati is working in a different environment and that this contract is of a larger size. But this is precisely the reason why Ms. Bubati wanted to get approval from her management, and the management approved the transaction, meaning that those 2 factors couldn't be that big of an issue. Thank you.
Thank you. Ms. Valova, Sir rebuttal on your side?
Members of the tribunal, the management approved the commercial terms of the transaction. However, after that, further negotiations were pending. And because of differences between the companies that we pointed out, the practices between Southern Commodities and Claimant remain irrelevant for the formation of a contract in the case at hand. Thank you.
Thank you very much. Are there any questions from the arbitrators? If that's not the case, then we stay on your side and continue with Mr. Ivanov on procedure. Go ahead.
Members of the tribunal, esteemed colleagues, my name is Ivan Ivanov, and as second counsel for respondent, I shall assist this tribunal on the issues of procedure. Today, opposing counsel seeks to compel respondent to take part in the present proceedings, despite the fact that the parties never validly agreed on an arbitration agreement. And to establish that, the tribunal shall first determine what is the applicable law to that instrument by virtue of Article 13, Paragraph 5 of the AIC rules which govern the present proceedings. The contentious issue between the parties, in summary, is whether or not to apply the law of the underlying sales transaction, Mediterranean law, which would then lead to a conclusion that most likely the arbitration agreement was not validly agreed on, or to apply the law of deceit, Danubia. And therefore, there will be a conclusion that under the Danubian law, there is a validly agreed on commercial arbitration agreement. And for all those reasons, we have two main submissions. First, Mediterranean law governs the arbitration agreement. And second, as a consequence, the CISG applies to the arbitration agreement. Starting with the first question, members of the tribunal, it is undisputed between the parties that we have not agreed on an explicit choice of law to govern the arbitration agreement. And in such circumstances, we would like to refer the tribunal to the applicable test in such circumstances, namely the test which can both be found in Article 5 of the New York Convention, to which both Danubia and Mediterranean are state parties, and Article 36 of the applicable lex arbitrii, here, the Danubian law. Now, under that test, it is provided that we shall first examine the explicit choice of law to govern the arbitration agreement, then the implicit choice of the parties in the absence of an express choice, and only if there is no choice at all, only in that situations, we may apply the law of the seat, in our case, the Danubian law. And in that regard, it is our submission that the choice of law for the sales contract, namely Mediterranean law, also extends to the arbitration agreement. And in that regard, we'd like to refer you to the 2020 decision of the United Kingdom Supreme Court in its Enka v. Chubb. And while we acknowledge that that decision comes from a common law jurisdiction, and it's not directly applicable in the context of a civil law jurisdiction such as Mediterranean and Danubia, we rely on that case not as a binding rule of law, but the mere interpretation of the intention of the parties. And in that case, it was established that it is only normal for business parties such as Ms. Bupati on one hand and Mr. Chandra on the other, when entering into a contract, to have one system of law to govern the whole of their relationship, both the commercial aspects and the procedural relations, such as, for example, the arbitration agreement. Now, we acknowledge that this is merely a general presumption, that it is provided and has to be assessed on a case-by-case basis. And in that particular case, actually, when the United Kingdom Supreme Court discussed and interpreted the intention of the parties, ultimately found that that presumption was not applicable and applied the law of the seat. What we are merely suggesting today is that we are not suggesting that it is impossible to have two different governing laws, one to govern the sale and one to govern the arbitration agreement. We are merely suggesting that this is not the general case, but more importantly, it is not the case at hand. And in that regard, I would like to refer you to page 12 of the record. And I promise this will be the last time, considering we have been referred several times on this particular page. Here, in the paragraph starting with following our discussion, it is provided what was the understanding of respondent in that particular situation. Ms. Bupati stated that the submission of the sales contract to Mediterranean law. Now, she did not state it, the submission of the sales contract only, but taking into account the sales contract in general, and considering that the sales contract also allegedly incorporates the arbitration clause, it can also be understood that in her mind, Ms. Bupati understood the Mediterranean law would not only govern the sale, but would also govern the arbitration agreement. In that regard,
I just challenge you on that conclusion, because I did notice that as well. But we do have a few indications here that make the sales contract, the arbitration agreement law should follow that of the main contract. It makes that a little bit unconvincing. First of all, the doctrine of separability must come into this somewhere, I'm guessing. But also in this particular instance, we've got the Danubian law as the original choice of law for both the main contract and the arbitration agreement under the old terms. And then secondly, in the very correspondence you're referring to, Ms. Bupati not only suggests Mediterranean law is fine for the sales agreement, but she's clearly under the impression at that point that the old arbitration agreement would apply, because she's talking about the palm oil institutional arbitration process. So she's clearly of the mindset that this is the old arbitration clause, which of course selected Danubian law. So how do you address those factors as being specific factual circumstances that seem to suggest in the opposite direction to that you're contending for?
Thank you, Madam Arbitrator. Now, one first note I would like to address is that the suggestion that Ms. Bupati was not aware of the actual content of the arbitration agreement actually supports Ms. Vulova's submissions on stating that respondent was not properly aware of the contents of the general terms and conditions, considering that she was requesting for a non-commodity institution, and currently there is such non-commodity institution. But to address your question, we acknowledge that in her mind, Ms. Bupati, it appears that she might have a separation. On one hand, the sales contract, and on the other, the issue of arbitration as a separate. But what we suggest here currently is that here it has to be noted that she merely distinguished and wanted to actually stress the fact that an arbitration in this particular context, in the political context, as brought up by Ms. Volova, is different. And it has to be consideration on whether or not arbitration will be pursued or not. And if it is pursued, under which circumstances. She is not necessarily given that she distinguished between those. And as to address the separability doctrine, we acknowledge the separability doctrine. It is both enshrined in the CISG, in the AIC rules, but we merely state that that doctrine merely provides to the presumption that if the underlying sales contract is invalid, this would not necessarily lead to the invalidation of the arbitration agreement. However, that doctrine does not provide for a presumption that we have to have necessarily two different governing clauses to cover both of those relationships, the one under the sales transaction and on the other under the arbitration agreement. And provided that that arbitration agreement was part of the contract, we may conclude that in the general framework of obligations, they were treated as one and the same. And in that regard, I would like to also address your attention to page 17 of the case file. Now here we see the response of claimant, and in the second paragraph, if the tribunal is with me, it is stated that the sale will be governed by the law of Mediterranean. And this actually points to an opposing argument, meaning that it was only the sale in the stricter sense, not necessarily any ancillary obligations. But the opposite argument can equally be the same. The sale may be taken into the context as the general transaction as a whole, not merely the commercial rights as a buyer and a seller, but any ancillary rights to pursue, for instance, arbitration proceedings or even civil litigation. And in that context, we submit that it is the general framework here that is governed by both by the law of Mediterranean. On one hand, the sale, and on the other, the arbitration agreement. Or in other words, one law to rule them all obligations within between the parties. But here,
sorry, Councillor, to interrupt you. Would that apply if you stay on page 17 for a second? Look at the next paragraph. Does that alter anything on what you're saying? It says, in addition, claimant's general conditions of sale apply to issues not regulated in the attached document. Wouldn't that be a clear indication that the rules in the conditions of sale, the general conditions of sale, do apply?
It might be taken as to indication, for instance, but we are merely suggesting that in the context of procedure, that general terms and conditions will be both governed by Mediterranean law in terms of the substantive provisions and the arbitration clause as such, as was distinguished by opposing counsel on the merits. But here, we'd like to briefly address very important considerations that might be taken into account as an opposite approach, namely the opposite approach applying the law of the seat, the Nubian law. We have several points to address under this argument. Why we should not apply the law of the seat? First, the Nubian law was never even discussed by the parties at any time, not at all. It was merely, why wouldn't the parties, for instance, merely included a separate choice of law provision? The first stating this contract shall be governed by the law of Mediterranean, and the second stating the arbitration agreement specifically will be governed by the Nubian law. They did not provide it for that. They did not even discuss that. But secondly, while we do acknowledge that there is practice, for instance, primarily in civil law jurisdictions, to favor the law of the seat, or in other words, when parties are choosing a seat, they implicitly choose a law to apply to their arbitration agreement. Why we should not follow that necessarily? Here we submit that the seat is very important in general. It provides for the applicable lex arbitri. It provides for the relevant rules for setting aside an arbitral award. It also provides, for example, in our particular case, as a neutral venue jurisdiction between the parties, considering that one comes from Mediterranean and the other for Equatoriana. But this is precisely the problem, honorable members of the tribunal. The seat, in our case, can be important for so many factors that it is not necessarily the case that when the parties chose the seat to be the Nubia, that they intended actually the Nubian law to apply to the arbitration agreement. And finally, if you allow me, we are aware with the diverging practice on this particular issue. Some courts prefer to have the general presumption that the underlying sales contract apply to the arbitration agreement. Other courts and tribunals want to apply the law of the seat. But we are not here today to argue that one decision is more important than the other, but to find a common ground between all of those decisions. And a common ground was, for example, the tribunals provided for the so-called validation approach, or in other words, they interpreted the intention of the parties in such a way as to provide for a law which would properly allow the arbitration agreement's life to prevail. But we should not apply it here in the dispute. And the reason for that is that our consent to go to arbitration was conditional, and the conditions to go to arbitration were not met. There were two main conditions to go to arbitration. One, the non-industry related institution, which we acknowledge that it is satisfied given the fact that the AIC is a non-commodity institution. But the second was transparency. We want transparency, and indeed, Ms. Bupati even referenced, for example, the UNCITRAL transparency rules. And while we acknowledge and agree that the UNCITRAL transparency rules can clearly do not come into a context of commercial arbitration, and this was also agreed by claimant and respondent, still, this is some sort of a level of transparency that they envisaged. They wanted that level of transparency, provided that economical context specifically brought up in Equatorial. And that particular context was concerning the environmentalist groups, which were castigating risks against the image of respondent. And here, indeed, as brought up by Madam Arbitrator, we did went to a mediation, and the very current proceedings are not transparent. But this is all irrelevant at the time, at the conclusion, at the contract. At that time, we wanted transparency, we insisted on it, and we provided that this was important given the particular context, which is also important with respect to the arbitration agreement. But finally, if you allow me, I'd like to address the issue of the CISG. Here, we have the following submission. We acknowledge the scope of the CISG. It is clearly stated under Article 1 to 3, and it stated that it provides and applies for contracts of sale. And we are not here to state that while contract of sale is not a defined term, we should interpret it in such a broader sense as to state that it applies to arbitration agreements, and arbitration agreement is a contract of sale. And as I see that my time will lapse, may I ask for one additional minute?
Yes, that's fine.
But the importance here is that when we took a systemic approach in reading the CISG, namely when we look at Article 19 of the CISG, which provides, for example, that the dispute resolution clause inclusion is a material change of a contract, or, for example, Article 81, which codifies the separability doctrine. When interpreting those two articles, courts have applied the CISG to arbitration agreement, as they have interpreted that the CISG is also intended to apply to arbitration agreements contained in a contract. And for example, that might be, we might refer you to the 2020 decision of the German Federal Supreme Court of Germany in its Mayflower decision, where precisely because of this systematic approach to the CISG, they have applied it to the arbitration agreements. And we acknowledge that we might appear a bit evolutionary in our approach, but the other approach, denying the application of the CISG, is certainly a bit too formalistic and a bit too old-fashioned considering the new practice. And for all those reasons, we submit that there is no valid arbitration agreement under the rules of Mediterranean law, particularly the rules of the CISG. Thank you.
Thank you very much, Counsel. Do my co-members on the panel have a question to the Counsel?
I have one small
Please.
question. That question is, I didn't hear very much mention in your presentation regarding the AIAC rules. Is there a default law of arbitration set by those rules, and does it assist you or does it run against you?
There is a default law regarding the seat of arbitration in that in the AIC rules. It namely provides that Kuala Lumpur shall be the seat of arbitration if there is no choice by the parties. However, we may concede for the purposes of these proceedings that there is a choice. But even there was not a choice, Kuala Lumpur would most likely not be the seat of arbitration, considering that it's either Kuala Lumpur or more appropriate jurisdiction. And here we submitted, considering that the Nubia was as mentioned, some sort of previously used, it might be considered as a appropriate jurisdiction. Thank you.
Thank you very much. If we have no further questions from the panel, then we would move on to counsel for claimant, Ms. Schmidt. The floor is yours.
Thank you, Mr. Presiding Arbitrator. My name is Lara Schmidt, and I will now speak on the procedure issues. Members of the tribunal, opposing counsel started his submission with alleging that the parties never concluded an arbitration agreement. However, opposing counsel at the same time acknowledged that under Danubian law, if a contract was concluded, the parties concluded a contract. Therefore, applying this law, it emerges that this jurisdiction that this tribunal has the jurisdiction to hear this case. Against this backdrop, claimant has three submissions. First, Danubian law and not Mediterranean law governs the formation of the arbitration agreement. Second, even if the tribunal should find that Mediterranean law applies, the CISG would not apply. Third, and most importantly, under the applicable law, the parties concluded an arbitration agreement. Starting with our first submission, Danubian law governs the arbitration agreement. Opposing counsel relied to determine the law applicable to the arbitration agreement on Article 5.1a of the New York Convention, respectively Article 36 of the Danubian arbitration law. And we would follow that approach. And we totally agree that the parties did not make any express choice regarding the law applicable to the arbitration agreement. However, what we strongly disagree with is that the parties made an implied choice for Mediterranean law. Members of the tribunal, it is our submission that the parties did not make any choice of law applicable to the arbitration agreement. In the following, I will first rebut the arguments of opposing counsel regarding the implied choice, and then come to the default rule of the New York Convention, which applies the law of the seat in absence of any choice. Before coming to the alleged implied choice, I want to pick up on the point opposing counsel made, namely that alleging that I will pick up on case law, that the seat of arbitration is a neutral place, and I will invoke the validation principle. None of that is the case. Opposing counsel relied on two main arguments to substantiate his submissions. First, the presumed intention of commercial parties as stated in Anchor versus Chubb. And secondly, the intention of our present parties, Mr. Chandra and Ms. Pupati. Those two factors cannot suffice to create an implied choice. For an implied choice, the parties' intentions need to be derived with sufficient certainty. All signs of the record must point in the same direction. And presently, there are also signs pointing in the opposite direction, in the opposite direction of Danubian law. Starting with opposing counsel's first argument. Opposing counsel relied on the intention of commercial parties, as presumed in the decision of Anchor versus Chubb. And opposing counsel correctly stated that this is just a presumption, a rebuttable presumption. And members of the tribunal, certainly, Mr. Chandra and Ms. Pupati are commercial parties, and business realities are an important consideration. However, the approach taken in Anchor versus Chubb does not fit the present case. Both of them, Mr. Chandra and Ms. Pupati, were advised by lawyers. It was actually a lawyer who decided to change the applicable law to Mediterranean law. And let me give you a little bit of context for that. Madam Arbitrator already asked the question or pointed out that Danubian law was the law of the sales contract in previous contracts. In that previous contracts, the seat of arbitration and the law of the sales contract had always been Danubian law. Therefore, no issue with the applicable law there. Then, claimant's lawyer decided to change the law applicable to the sales contract and to Mediterranean law. And this change was reasoned with an unjustified termination in the past due to problems with the supply chain. Therefore, this change had nothing to do with the arbitration agreement. It was only related to the sales contract.
May I interrupt you, Councillor, here for a second? I'm wondering, when I've read that on Exhibit C4, which is actually the email from Mr. Ryan you're referring to, I mean, the word sale here is not in capital letters written. So doesn't that mean the whole transaction shall be governed by the laws of Mediterranean instead of just the merits of the transaction?
Mr. Presiding Arbitrator, I would respectfully disagree. And this actually leads me to the second argument opposing counsel made, namely that the parties did not differentiate. And what we can see in the email you just pointed us to, Mr. Presiding Arbitrator, is that Mr. Rain differentiated. It holds true. In the second paragraph, he states, the sale will be governed by the law of Mediterranean. But we have to take into consideration the whole document. In paragraph 1, members of the tribunal, if you are with me on that page, in the last line, starting with, I have inserted, I quote, I have inserted the terms of your offer into the contract, which we accept. What can be derived from that is that Mr. Rain differentiated here. When it comes to the contract, meaning the contract as a whole, with all terms, including the arbitration agreement, he wrote contract. But when it comes to Mediterranean law, he wrote sale. And members of the tribunal, we are aware Mr. Rain is a businessman. And therefore, we should not take every of his words literally in a legal sense. However, this differentiation here was made by all other executives who are involved in these negotiations, by Mr. Chandra, by Ms. Bopati, by Mr. Rain, as shown, and by Ms. Fauconnier. All of them.
I'm not so sure that that's really evident on the facts. It seems to me that your client has almost engaged in some contrary behaviour here, because on the one hand, they're indicating, and as you say, business people may not differentiate, but they're indicating Mediterranean law, not Danubian law. And therefore, you know, to then turn around and say, hey, Danubian law applies to the arbitration agreement seems rather contrary. But there's one more factor I'd like you to address very briefly, and that is, why should the tribunal be predisposed to applying a different law to one clause, and I know it's an arbitration agreement, rather than have Mediterranean law apply to the whole thing? Because it seems to me that could be a recipe for a great big mess.
Madam Arbitrator, addressing the first issue, I would disagree with the fact that this is contradictory, because this is exactly the point. When it comes to the sale, they just mean the sales contract, using the term sale, only the sales contract. However, the parties do not only refer to the sales contract, but differentiate with making the term contract clear. And to the second point, that applying to, one law to only one clause of the general conditions, there's no issue with just applying that clause. According to the Doctrine of Separability, as also stipulated in Rule 20.1a of the AIC rules, the contract, the sales contract, and the arbitration agreement are independent, and therefore a different law can apply. And presently, if a different law applies, an arbitration agreement is concluded presently.
But isn't that doctrine of separability, as encapsulated, as you mentioned, really all about saving an arbitration agreement where the contract is considered to be invalid? And really what you're proposing is trying to make the separability doctrine do something quite different, something I think we could say is possibly outside its scope. So what authorities do you rely on for this approach to separability, to stretch it beyond just invalidity? And also, aren't you really just trying to take a second bite at the cherry here, that if you sort of essentially can say a different law applies to the arbitration agreement, that's another way to get it incorporated if you fail on the general conditions?
Madam Arbitrator, first addressing the issue of the doctrine of separability. We are not relying on a very, very broad interpretation of the doctrine of separability. What we are submitting, what the doctrine of separability means, is that a different law can apply. I think that is something we can all agree on. A different law can apply, and that happens in a lot of contracts.
And what authorities do you have to say it can be a different law, but it can apply in circumstances other than validity of the contract being threatened?
As opposing counsel named, for example, also in Anchor versus Chubb, there is a presumption that the law of the sales contract also governs the arbitration agreement. We agree with that. However, it is a presumption, and what is our submission here? That the presumption is rebutted in the present case because the parties were aware that a different law may govern the arbitration agreement. It is our submission here that there is no clear intention of the parties to apply Mediterranean law, but signs in both directions, Mediterranean and Danubia. And we should not impute a choice by the parties and assume what were their intentions, but just admit that we cannot derive a choice by the parties in the present case, because there are also circumstances in the record that show us that maybe the parties intended to apply Danubian law, but maybe they intended to apply Mediterranean law. In the end, we don't know.
And who bears the onus of proof on that?
Excuse me, Madam Arbitrator, could you rephrase that question?
Who bears the onus of proof to prove one way or the other? Which party?
It is on respondent to prove that the arbitration agreement is not concluded in the present case. If that answers your question?
Yes, I think so. Thank you.
To proceed with our submission, there is no implied choice by the parties, and therefore we must turn to the default rule stipulated in Article 5.1a of the New Convention. And this provision calls for the law of the country where the award was made, in this case, Danubian law. To conclude our first submission, Danubian law applies to the arbitration agreement. But members of the tribunal, even if you should find that Mediterranean law applies to the arbitration agreement, the CISG would not apply. Opposing counsel was relying on decision of the German Federal Court of Justice in 2020 in the ground-based case. And we acknowledge as a matter of fact that in this decision, the German Federal Court of Justice decided that the CISG applies. But this decision also stipulated that there are dissenting opinions on that issue. As for example, Professor Stefan Kröll also stipulates that the CISG does not apply, as well as the Swiss Supreme Court in a decision in 2001. Therefore, this issue is not a question of more case law, but a question of substantive arguments. And in this regard, in the answer to opposing counsel's argument, I will make 2 points. First, the sphere of application excludes the application of the CISG. And second, Article 19, Section 3 does not provide for the application of the CISG. But starting with the scope of application. Opposing counsel acknowledged that according to Article 1, 2, 3 of the CISG, the scope of application is limited to sales contracts. However, opposing counsel was also alleging that the term sales contract is not defined and needs a broad interpretation. But the term sales contract can actually be defined by the provisions of the CISG. By Article 53, is there a question? So the term of the sales contract can be defined by Article 53 of the CISG and Article 35 of the CISG. Those provisions state the obligations of the seller and the buyer. And from that provisions, it can be derived that the essence of a sales contract is the exchange from goods for money. Now, an arbitration agreement does not or is not specified by an exchange of goods for money. It is a procedure contract containing terms for the settlement of disputes. And therefore, an arbitration agreement does not fall within the scope of application.
But on your definition that you've just outlined for us, wouldn't also services fall outside the scope of the CISG?
No, Madam Arbitrator. However, service agreements do have like a clearer or nearer content to sales contract than arbitration agreements. As stipulated in the Doctrine of Separability, the arbitration agreement and the sales contract are considered as separate. And a procedure contract stipulates the rights and obligation to arbitrate in front of a tribunal in case of dispute. It is a dispute resolution mechanism and not a sales contract.
But let me add on that, is it then completely within the system that Article 19, para 3 talks about material alterations, including dispute resolution clauses?
Mr. Presiding Arbitrator, I see my time has elapsed, but I assume I was still answering your question.
Sure.
Article 19, Section 3 must be seen in its context. in the context with Article 19, Section 2 of the CISG. According to this provision, material alterations in the reply to an offer hinder the formation of a contract. Now, Article 19, Section 3 gives examples what such material alteration is. Historically, there have been a huge debate at the conference of the CISG, what is a material alteration? And therefore, the drafters intended or decided to implement Article 19, Section 3 to give such examples what a material alteration is, to specify the broad term of material alteration. There was no discussion whether the CISG should apply to arbitration agreements. There was no intention to extend the clear scope of the CISG to arbitration agreements. Of course, a dispute resolution mechanism is important for the conclusion of a contract, and that's why it is stipulated in Article 19, Section 3. But this has nothing to do with the application of the CISG to arbitration agreements.
Okay, thank you. I'm looking to my fellow members on the panel if they have an additional question to Ms. Schmidt at this point.
My one brief follow-up question in relation to your last point on Article 19.3 is that, are you saying then these examples mean that any additional examples are excluded? This is the entirety of the intention of Article 19 and the drafters of such such provision, or, for example, if this was a provision, a material or an alteration that was not an arbitration agreement, but was not listed in Article 19.3, would this then perhaps constitute a material alteration?
No, Madam Arbitrator, the list in Article 19, Section 3 is just giving examples, the presumption that these terms are material. Of course, what is material must be determined in each case in the particular circumstances, but it gives examples and it shows the intention of the drafters that usually disregarding term of the settlement of disputes is a material alteration, but this does not exclude that maybe other terms be considered as material in the particular circumstances of each case.
But the settlement of disputes is a material alteration.
Yes.
For sure.
That, of course, begs the question, how can it be an alteration if it's not part of the contract? But I do have one question which I'd prefer to go to, if I may. Counsel, if the CISG is held by this tribunal to apply to the arbitration agreement, and if the tribunal were to hold against you on the issue of reliance on past practices, can the claimant in any way satisfy the threshold of the in-writing requirement under Article 7 of the Danubian arbitration law? And here I'm thinking particularly Article 7, subsection 6.
Yes, Madam Arbitrator, because according to Article 7, Section 6, the general conditions must be included into the contract. And as my co-counsel elaborated, these general conditions were included under the CISG. And therefore, the arbitration agreement is formally valid according to Article 7.6.
Okay, and so you're saying even without past practices, you can satisfy the made available test under the CISG in regard to the arbitration agreement?
No, we cannot. If the tribunal considers that there's no business relationship at all between the parties, we would submit that the general conditions were not made available to respondent and therefore also no arbitration agreement under the CISG. However, Danubian law applies to the arbitration agreement and their general conditions do not have to be made available. Therefore, even if the tribunal considered that there's no business practice or no business relationship, there's still an arbitration agreement concluded under Danubian law.
Thank you.
Well, thank you very much. I'm sure Ms. Ivanov is already waiting for his rebuttal.
Members of the tribunal, taking you back to the important issue of whether or not the parties intended to extend Mediterranean law to the arbitration agreement. On page 50, clarification 16, we see that the external counsel of claimant decided to apply the CISG in the context of Mediterranean law after he found out that a scholar has actually argued against the extension of the CISG to arbitration agreements. Now, why wouldn't that be? If a lawyer of claimant was hesitant to actually apply the CISG as part of Mediterranean law to the contract, given the reason that it might extend to arbitration agreements, it actually points to the fact that he feared that Mediterranean law actually extends to the arbitration agreement, and every obligation under that contract, both substantive and procedural, are governed by one law. Thank you.
Thank you, Mr. Ivanov. Do we hear a rebuttal from Ms. Schmidt?
Yes, Mr. Presiding Arbitrator.
Please.
Claimant is not afraid that the CISG extends to the arbitration agreement or Mediterranean law extends to the arbitration agreement. What we are submitting, we're staying with the law, and according to that rules, according to Article 5.1a, Danubian law applies. Thank you.
Thank you very much. Well, with that, I guess that concludes our hearing of today. Let me, before the tribunal now goes to deliberation in its deliberation room, and we'll discuss in great detail what we have heard from you over the last 1.5 hours. I would not like to close the session without having said that you are at a very lucky position because you're already winners, all four. Not only because you made it to the finals, but you made an outstanding performance today. And I'm sure that my two co-members on the tribunal will join in by compliment you for on this really outstanding performance you have given today to us. It is going to be a very difficult deliberation for us, but that is something we used sometimes, not so often. I can tell you there would be many practitioners who would probably love to give this performance you have been given this afternoon and make it so difficult for a tribunal as us to make a decision. So congratulations and thank you very much. I'm wondering whether my colleagues would like to add something to that from your side.
Thank you, Mr. Chairman. I have nothing to add, but just to echo all the sentiment that has been expressed already. The performance of all four of you have been superior, and certainly as an arbitrator, we would have great pleasure in hearing any of you in the future. So many congratulations for an excellent performance.
Thank you, Sharon.
Yes, and I would also add to that an outstanding effort, and very impressed with you all. So thank you so much. It was a pleasure to hear you plead today.
Well, thank you very much. Then let's conclude the hearing of today, and we will go to our breakout rooms and discuss further. And we will hear the outcome at the closing of the moot. And until that, we will have a good discussion amongst the arbitrators. Thank you very much. And this is the closure of today's hearing.
Thank you very much.
Thank you.